the whole question of freedom of religion is about this hedge against tyranny. So yes, it is about fostering religious pluralism on the one hand, but these were not churchy guys. Like Thomas Jefferson, who writes to James Madison advocating for an amendment that would protect freedom of religion, is not someone who is especially religious. But he believes that if the people are free to practice religion whatever way they choose, they will cultivate their own allegiances and values and their own systems of being. And that means when the state comes along peddling its orthodoxies, the people might be imbued with their own sense of value and be able to say, I don't agree with that. I don't want that. And they will stand up and resist.
There you go. Welcome, good evening. Welcome back to San Francisco.
Thanks for having me.
I'm Neil Chase, I'm the CEO at Cal Matters. And a couple of quick announcements before we get started. This won't surprise you. This is being recorded for radio. Please silence your cell phones for the whole program. If you have questions for Melissa, and I know you do, a lot of us do, fill them out on the question cards you've got at your seat, or if you're online, fill them out through the YouTube chat, and we'll get them that way. And now I have the pleasure of introducing and welcoming back to the Bay Area, Melissa Murray. Melissa is, as you know, a leading legal expert, the author of the U.S. Constitution. I love that part, just the author of the U.S. Constitution.
James Madison would like a word.
Yes, exactly, exactly. James Madison is probably busy spinning in his grave right now.
Well, he probably wonders who taught me how to read and write.
There is that.
There's that.
There is that. The book is subtitled A Comprehensive and Annotated Guide for the Modern Reader, which we're going to talk about in a second. You are the Frederick I. and Grace Stokes Professor of Law at New York University School of Law, the host of Strict Scrutiny. I don't think we have to tell anybody that. And previously, across the bay at the University of California's Berkeley School of Law, you were the interim dean of the law school and a professor. So very good to have you here and to have you back.
Thank you.
I was going to start by asking one of those book talk questions, like, why this book, why now? And then last week, the Supreme Court kind of answered my question. So
They keep doing that. They keep
doing that. So let's just jump in. The purpose of the book seems to be to help people understand what the Constitution actually says. And I thought it was for the modern reader, the average person, but who really needs to be taught what the Constitution says? Because last week it seemed a little unclear as to whether anybody knows what it says.
So the origin story of the book actually begins with Twitter. So I'm not on Twitter anymore, but there was a
We
period.
all say that, yeah.
No, I really am not. I can't stomach it anymore. But there was a time when I was in the Twitter streets all of the time. And I came across someone from my childhood. So I grew up in Florida, and Luke Campbell was the lead in Two Live Crew. And I had two very strict Jamaican parents who never allowed me to listen to Two Live Crew, which meant I always listened to Two Live Crew when I was with my friends or whatnot. Anyway, I was in the Twitter streets, and Luke Campbell, Uncle Luke, was on Twitter, and he was just going off about Joe Biden. He's really mad at Joe Biden. He had all these things he wanted Joe Biden to do. He wanted Joe Biden to lower the cost of groceries, lower the price of gas, do this about police brutality, on and on and on. And as I read the list, I was like, well, this is a very good list. But only a third of these things are things that the president is constitutionally authorized to do. Many of them were things that could be done by a local mayor, maybe things that could be done by Congress, maybe things that could be done by your city council, but not by your president. And it occurred to me that despite his impressive oeuvre, Uncle Luke had not read the Constitution. And maybe a lot of people hadn't. Maybe people who need to read the Constitution hadn't read the Constitution. And I know now that Uncle Luke is running for Congress, so I hope he has, picked up this book along the way. But it occurred to me that the real people who need to read the Constitution goes beyond Uncle Luke. It's us. We need to read the Constitution. Like, this was a document that was intended to be debated and grappled with and read. Right? They knew that they wanted the people to be deeply engaged with this document. And I don't know that we are right now. So when I teach constitutional law, the first assignment for my students is to read the Constitution. And I think it may be the first time that any of them
Wow.
have read the Constitution all the way through. And I mean, let's be realistic. I don't know if they really did at all. Like, I mean,
But it's got to be easier to read the Constitution with you sitting at my side explaining it as I read, right? Going through the book, you are reading the Constitution, but the context is so important. And I was going to say always, but especially now, and especially the last 5 days.
So I think the context is hugely important. I start the book off with this preface that talks about the origins of it. And I think most people understand, there was the Articles of Confederation, like right after the Declaration of Independence, and then we fought this war, and then they were like, oh my gosh, the Articles are terrible, we should do something else.
That's about all we know. Yeah.
But when you really dig in, you realize that the framers, when they headed to Philadelphia in the sweltering summer of 1787, they're actually going through trauma, right? So they have the trauma of the colonial period where the British Parliament has taxed them relentlessly, making the cost of things they use every day unrelentingly high. And then they also have this trauma of the king sending the redcoats into their cities where, not only do they have to deal with the army being used for domestic law enforcement, but they have to house them and feed them too, like the indignity of that. And then once they're done and they've declared their independence, they have this additional trauma because they now have to fight this war against the greatest global superpower that anyone has ever seen. And they're doing it with this government that they've cobbled together with gum and friendship bracelets. I mean, it's just like a terrible idea. And improbably, they are successful. But when they come out of it, they realize they have to do something different. They have to create a government that is strong enough to be effective, but not so strong that it will slip into tyranny the way they imagined the British Parliament and the British king had become tyrannical. So they're trying to strike this delicate balance, and they do it in a couple of ways, right? So first, they divide government power between the states, which they believe will be closest to the people and more likely to be protective of the people and their interests, and then the federal government. And then they take the power that they've allocated to the federal government and divide it between these three coordinate branches, each with the power to check the other, such that no branch can consolidate power and become tyrannical. Right? That part is critical. Like, it's a hedge against tyranny, this idea of limited government. And even at that point, they realize that maybe they haven't gone far enough. There are those among them, Patrick Henry, George Mason among them, who say that it's not enough to just do this through structure. You have to actually imbue the people with explicit rights. So almost as soon as the Constitution is ratified, there are people calling for it to be amended, and it is in fact amended. The first 10 amendments are the Bill of Rights, which give them explicit rights, free speech, religion, and even the whole question of freedom of religion is about this hedge against tyranny. So yes, it is about fostering religious pluralism on the one hand, but these were not churchy guys. Like Thomas Jefferson, who writes to James Madison advocating for an amendment that would protect freedom of religion, is not someone who is especially religious. But he believes that if the people are free to practice religion whatever way they choose, they will cultivate their own allegiances and values and their own systems of being. And that means when the state comes along peddling its orthodoxies, the people might be imbued with their own sense of value and be able to say, I don't agree with that. I don't want that. And they will stand up and resist. Right? So that too is a hedge against tyranny. This is the whole game for them. They do not want a tyrannical government. And so they understand in this moment, they are not simply crafting a new model of government. They are crafting a new model for the governed. They need a citizenry that will be able to stand up, and a citizenry that can stand up to the state is one that is informed, that is knowledgeable of the limits of government power, that is knowledgeable of their rights, and that are prepared to defend those limits and those rights zealously.
And that knowledge starts with at least having read the Constitution.
I would think.
You would hope, right?
I would think.
So they built these hedges against tyranny. They could not have seen a world where, you took an Uber over to the Bay Bridge to get to your session at the Commonwealth Club that's on YouTube. But they tried the best they could to build it in a way that would adapt over time, and it adapted through a lot of different things, right? But were they ever expecting a time when one branch of government went to sleep and the other one was bought by the third. Not to inject opinion into this, but could they have imagined a situation like we have now? Is it their fault for missing it? Is it unimaginable yet it's happening?
Well, so I think they did not imagine this. They did imagine that there might be at some time a leader who would be self-interested, not high-minded, someone who is out for himself. And they talk about this very explicitly. They just imagine that everyone will not be enthralled by this person, right? That there will be people who are skeptical, who are themselves high-minded, and they will stand up to this person. They imagine that Congress will guard its prerogatives jealously. They imagine that the Supreme Court will step in. And so, they also don't imagine political parties, right? So that's something that was not fully on the radar. And because it's not on the radar, I don't think they reckoned with the kind of partisan polarization we experience today. And so, yes, there are some blind spots, but, could they have imagined someone with tyrannical tendencies? Certainly. They understood that, but they thought that what they were doing would be enough to guard against a person like that taking power and taking over the government, because they saw it as like, this is what a king does. This is what a parliament does. And they thought they had hedged against that.
Yeah. So take us all the way to last week. And if we can, we could go through all the history, but you get to a situation like last week, the birthright citizenship case, right? How do we get there? How do you get to the point where you just wrote a book to help most of the people who've never read it read the Constitution, and it leaves you perplexed as to how the people whose job is to read the Constitution are reading the Constitution?
So this seems not to be a question about the book, but a question about...
That's fair. That's fair.
Okay. Which I'm happy to talk about. I think this was the easiest question for this Supreme Court to answer because the text is incredibly straightforward. Section 1 of the first part of the 14th Amendment says explicitly, those who are born in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. It's very straightforward. It is meant to restore what had been a common law default that had been adopted during the colonial period. And the common law default was known as jus soli, citizenship of the soil. And the idea was if you were born in a place, you were a citizen of that place. And when the Americas colonies became the United States of America, they adopted that as their rule. And it was the rule until 1857 when the Supreme Court comes along in Dred Scott versus Sanford and says that that is the rule for everyone but African Americans. Those who are descended from the enslaved, whether they are free or not, can never be birthright citizens of the United States. Obviously, that precipitates the American Civil War. In the wake of the war and as part of the Reconstruction Amendments, the 14th Amendment is ratified. The first section is the Citizenship Clause that is meant to repudiate Dred Scott. Now, the president's executive order, as defended by the Solicitor General John Sauer, trades on that history, but not in a way that I think is intellectually honest. So John Sauer, in defending the executive order at the Supreme Court, says that the framers of the 14th Amendment were only intended to restore citizenship for the children of the formerly enslaved, the babies of slaves, as the president has said. That's not true, right? So they're restoring this common law default. They are well aware that immigration is happening. They know about the Great Potato Famine of the 1840s and that there's a huge influx of Irish immigrants. They know that the gold rush here on the West Coast has precipitated an influx of immigrants from Asia. They know all of this. They recognize that some of these people who are coming from other parts of the world are absolutely ineligible for citizenship in the United States, and they're still grappling with this question, what do we do about their children if they are born here? And the Congressional Globe is replete with the evidence of these debates, the back and forth of people going, well, no, they shouldn't be citizens. Yes, they should. They ultimately arrive at a broad rule that we are restoring this common law default, and it will apply to everyone. That's the history, and it's very straightforward. And so I think the very least we can expect of the Supreme Court is that they will all read.
And read your book.
They don't even have to read my book. Like, I don't think you need an explanation for this one. It's so straightforward and clear. And it is an absolute travesty that this was not a unanimous decision, because it is very straightforward. I knew at oral argument it would not be a unanimous decision. I thought it would likely be a 7-2 decision. I was floored to find it a 5-4 decision. And if you listen to people, I was just on a panel in Aspen with someone who told me this is a 6-3 decision. It's a 6-3 decision only on the question of whether the president can rescind birthright citizenship via an executive order. So 6 people in the court don't think he can do it. 5 people on the court don't think the Constitution says what it says. And that, to me, is the more alarming prospect. Birthright citizenship is literally hanging by a thread. And Brett Kavanaugh, in his concurrence/dissent, has created a roadmap for stoking the legal questions that will, I think, occupy us for the next 10, 15, 20 years, that I think will be, as abortion was at one point, a project that will slowly move toward what effectively will be the rescission of birthright citizenship for some among us.
And that roadmap includes almost instructions to Congress.
Yes.
Right? Here's
Congress
how to do it.
can do this. Yeah.
Yeah.
The 14th Amendment doesn't protect it the way that 4 people, like the way 5 people in the court say that it does. And Congress can rescind this whenever it likes. And, the President of the United States and the Vice President of the United States have now called on Congress to do exactly that.
They're speaking exactly like what you described, a campaign. This is a long-term project.
And this is the thing. Listen, I work in the media. I get it. They try really hard. Many of them have not been to law school, and that's okay. That's why I come on MS Now occasionally. But I can't emphasize this enough. For those who are trumpeting that this was a victory, you are missing the point. This is a hollow victory. It is a for now victory. It is laying the groundwork for what will be a coordinated campaign to play up the threat of quote unquote birth tourism, and to play up the fears around the changing demographic character of this country. And I don't know when it'll be, but they are moving toward ultimately rescinding this.
And that is a patient process, right? I mean, it could happen next year, it could happen in 5 or 10 or 20 years or 5 different administrations.
We've seen these people play a long game.
Yeah, exactly. Yeah. Fascinating. You talk a lot in the book about things that can be read different ways or things that weren't clear in the Constitution that had to be. That one just didn't strike any of us as a hard to read sentence, right?
That was pretty straightforward. Yeah, that was straightforward.
Let me ask you about another one as a journalist. You explain the first line of the First Amendment, Congress shall pass no law, and that it was later come to understand that means no government in the United, no state or local government can do that. Given how tenuous everything else is, what's to stop the San Francisco Board of Supervisors, or maybe more likely the Huntington Beach City Council, from doing something that clearly violates the First Amendment and saying, you know what, we'll just take this to the Supreme Court. They'll hear it. Is that ludicrous? Is that realistic?
No. I don't think anything is off the table with this court. To be fair, I am not a radical. I really am not. Like when I worked at Berkeley, I wore blazers. That's how conservative I am. I'm a pretty practical person. This term at the court, I think perhaps more than any other, has radicalized me. I didn't talk about Supreme Court reform that much. Some of my colleagues did. I didn't. I truly think that this court is an existential threat to democratic institutions, and we have to reckon with that.
So that means there has to be reform of some kind?
I mean, again, I think everything should be on the table, which is not to say that, some reforms are not going to be a race to the bottom. I think if you expand the court, it's going to keep expanding and contracting over time. And maybe that's okay. Maybe that's what's necessary in the short term to recalibrate a court that has been captured and captured through means that are anti-democratic. I mean, I have no problem saying this. I think Neil Gorsuch's seat is a stolen seat. I don't feel like that about Amy Coney Barrett. I think, if you're the president and there's a vacancy on your watch, you get to name the successor to that seat. But Neil Gorsuch's seat was vacant from February 16th of 2016 until Donald Trump named Neil Gorsuch to it. Barack Obama should have named the successor to that seat. Yeah.
So do you, with the various reforms that are talked about, expanding to 13 because we have 13 circuits, something based on a reason to go to 13 that wouldn't say it's okay to go to 15 or 20, or are there some, where would you start if you could reform the court tomorrow?
So I think you have to understand that we can try to be reasonable about this, and 13 makes sense because there are 13 federal circuits, but it's not going to hold when someone else wants to expand the court or contract it. So,
as we just saw with congressional districts in Texas and in California.
I mean, we've never had mid-cycle redistricting until someone decided, he was not going to be impeached again. And we should have these districts redrawn in a way that allows the Republican Party to maintain control of the House of Representatives. So even if you are going to impose reasonable limits, I just don't think they'll hold. This is going to be a tit for tat. I do think there are important reforms that aren't necessarily as prone to politicization. So, I think term limits can be a more effective way and could take the temperature down, I think, on the confirmation process. If every president could be assured that she would get to nominate one or two people, I think it would take...
Framers didn't expect people to live to 100.
Well, they didn't expect people to live to be 100. I think they also thought people would cycle in and out of government in different jobs. John Jay was the first Chief Justice of the United States, and he was like, I hate this. I want to do something else. So this idea of, staying in the job, and being carried out, I don't think they thought about that in quite the same way that, that has come to be the pattern here. I think ethics reform is a very clear and obvious need. The Supreme Court should not have emotional support billionaires. Right? If I fly commercial, so should you. Right? Unless you have your own private plane. And if maybe you do, but seems
then you
unlikely.
Need to disclose it.
Well, disclose it, or follow the same rules as everyone else. It is honestly shocking at this point, the cozy interest. The fact that there is a group that purchased a building across the street from the Supreme Court so they could have meet cutes with the justices and just casually run into them and glaze them is weird. Just frankly, really weird. And it just tells you how much control and power this court has, maybe more than was expected at the framing, and how powerful it has become in our lives.
Yeah, it's shocking. You talk in the book a lot about the fact that so many things can be changed, things that Congress can make changes to things that I think a lot of people don't understand until you kind of go through the book and get a sense of what's actually there and what is left for Congress to decide and change, right? And some of these Supreme Court reforms, for instance, Congress could just do.
Jurisdiction stripping, preventing the court from reviewing certain questions, that's something Congress can do and has done. The Prison Litigation Reform Act is a jurisdiction stripping statute that Congress passed that prevents federal courts from hearing certain cases from prisoners. We can do it in other ways. We can limit the court's jurisdiction over voting rights. And some people worry that that means we will also be limiting the role of lower federal courts. And it's actually the lower courts and the district courts that are acting as the bulwark right now against the administration. So maybe jurisdiction stripping isn't desirable because it would also hem them in. But there are those who think that jurisdiction stripping over certain issues would be important and useful. You could do something where Congress passes a law that effectively makes each justice, if they hit a certain term limit, like if it's 18 years or not, they cycle back to the appellate courts and ride circuit. So it is effectively a term limit, but one that doesn't require a constitutional amendment. That's something Congress might be able to do.
Yeah. As you go through the amendments, the book ends with the 27th Amendment. Do we have a 28th? Did you think about addressing the Equal Rights Amendment at all in the book? Would it be appropriate?
So I thought about this. I should also say, I worked on this project with some really fantastic research assistants who were my law students at NYU, among them Sam Ozer-Staten, who is a Bay Area native, and I think he's here tonight. The Ozer-Statens are in the house. So I worked with another student, Ashni Verma, on this, and Ashni worked on the 19th Amendment, which is about women's suffrage, and we talked about this question of should I include the ERA, and one of the things I was really keen to do with this book was to kind of play it down the middle. Some people say this, some people say that, in part because I wanted people to arrive at their own conclusions about what they thought about the various amendments, the various provisions of the Constitution, and how they had been interpreted. I felt that talking about the Equal Rights Amendment, there was no way to do that, at least for me, in a way that didn't sort of tip my hand about what I thought about the ERA and its very tortured history. I will also say that at the beginning of working on this project, which is, I started working on it just before the presidential election of 2024, and on the Friday before the second Trump inauguration, I got a call from someone in the White House explaining that President Biden had announced through a presidential proclamation that the ERA was, according to him, part of the Constitution and, was the 28th Amendment.
Yeah.
And I was kind of like, what are we doing? Like this would have been nice 2 years ago when Dobbs was announced. So it seemed a little like too little, too late. I think it was obviously symbolic and good for President Biden for doing it and making it a topic of conversation. But there are real questions around the ERA, questions that may be resolved by the court in the future. Just sort of generally, what do you do about an amendment that has timed out, if one can even do that with an amendment? But I felt that including it would tip my hand about what I thought about some of those questions, which I didn't want to do.
Do you have an opinion on the question of if 38 states have ratified the amendment, is it part of the Constitution? Or is that what you were trying to stay away from opining on?
So I think the real question is what happens when there is a time limit imposed and the time limit occurs and you don't have the requisite number of states who have ratified? Because a lot of the ratifications came after 2016. And I think that's a tougher question, and I'm not actually sure I know the answer.
Okay. Some very good questions here from the audience. There are a lot of things, obviously, but what do you think is the greatest thing that people don't understand about the Constitution? Either a misunderstood concept or a myth that actually isn't true, or one of them?
So all of the folks who go to Elon Musk's Twitter law school, who are on Twitter, and every time someone's like, you're violating my First Amendment rights, and it's always directed at some person. No, most of the rights in the Constitution do not apply against private people. They apply against government entities, so state and local governments, the federal government, not private parties. There are a couple of exceptions. The 13th Amendment does apply to private parties, so individuals cannot maintain the institution of slavery. Prohibition also dealt with private conduct, not on the part of the state exclusively. But for the most part, and again, people don't recognize this, the Constitution and its provisions apply to restrict state actors. And again, that's the hedge against tyranny, the government being the unit that could slip into tyranny. And I remember, I have two children, and I think they're incredibly lucky to be raised by two lawyers. Like my parents were not lawyers, so I was probably one of these people talking about my constitutional rights and not knowing anything until I went to law school. But I remember when my daughter was 7, she said I'd infringed upon her rights. I was like, that's
and
actually.
She's taking you to the Supreme Court?
Well, she was just like, you're violating my rights. And I was like, your constitutional rights only apply against government actors. And she looked at me and she's like, don't you work for the University of California?
Ooh. Oh.
No. Here I was trying to raise a smart girl. I didn't know it would be weaponized against me.
She had clearly read the Constitution.
No, I hope she has at this point. I keep leaving the book around the house. I hope someone's reading
She'll say
it.
she has. So you hope someone's reading it. Who, certainly, this will be used in a lot of contexts where people want to understand the Constitution better. Who do you hope will read it that really needs it, hasn't seen it? Where do you?
Sam Alito.
Okay. It's on the beach in retirement
Long Beach, I don't know, Long Beach Island in New Jersey.
when he's
maybe.
retired.
Maybe. Who knows?
Who?
Clarence Thomas.
Clarence Thomas. I could have guessed
Brett
that was the next
Kavanaugh.
one. Yeah.
We could go on.
Brett Kavanaugh, who you warned us about, to be fair. You went before the committee
I tried to tell you.
at his confirmation
I
and
did.
explained why he was not a good choice.
I did.
You tried. We
tried.
appreciate that. Who, like, for instance, are there, what would cause a real change? How does this book actually change things?
Yeah.
Which group of people? Is it students? Are there people on what you might call the right who never watch MS Now who might find this illuminating?
I think so. I mean, again, part of trying to write this straight down the middle, sort of some people say this, some people say that, is because I do want it to be read by a wide range of people. I recognize that there are built-in audiences for me, and they may not trend right. That's unfortunate. I hope other people will come to this, but the book is written specifically for lay people. It's not for law professors. It's not even really for lawyers. Larry Tribe read it and called me and was like, what about this, Melissa? What about that? And I'm like, it's not for us, Larry. It's not for us. Like, you wrote a whole treatise. That's for us. This is for, my mom, who was a nurse but had questions about the Constitution and, would have, I think, liked to have something like this. I think it's especially important for students, high school students, middle school students. I think the book is accessible to them. I was a graduation speaker at a high school commencement, and I gave each graduate a copy of the book because I thought, you're going out into the world and we need you to be engaged. And so part of it is, I went to the University of Virginia, and the University of Virginia was founded by Thomas Jefferson, and at UVA, you talk about Thomas Jefferson like he went out for ice and he will be back any minute.
Wow. Do you talk about all the aspects of his history?
So I worked at Monticello, Thomas Jefferson's plantation home. So you don't get to be a Black woman working at Monticello without talking about all aspects of his history. And so I did. And at one point in time, I think I was required to know 387 Thomas Jefferson quotes.
Wow.
But right now, I can remember only one. And it was from an 1816 letter that Jefferson wrote to Charles Yancey. And he said, "A nation that expects to be both uneducated and free expects what never was and never will be." Right? They understood education as the ultimate hedge against tyranny. Like, an educated citizenry, you couldn't pull the wool over their eyes. So, part of the impetus for this book is we're getting snookered here. And we need to get back in the game, whether that's teaching our children what the limits of government are and, the boundaries that we place on the government, what our rights are, and when the government goes too far in encroaching upon them, or whether we need a refresher for ourselves. I mean, as I was writing this, I was seeing all of these debates in the Constitutional Convention about a standing army. The Founding Fathers were so preoccupied by the prospect of keeping an army. They really, really worried about it because, again, they remembered the Redcoats just being sent to Boston and Concord and wherever. And they were really worried about the United States having a standing army. They knew it was necessary. They'd just come through a war, but they're like, how do we do this and not have it turn into a force for the government to run roughshod over the people? And so they divided power over the military between the president, who would be the commander-in-chief, and Congress, who would provision and supply the army and would have to continually allocate funds for its upkeep. And they thought, that's how we'll do it. We're going to divide the power over this. They would have been so alarmed by what we saw in 2025 and 2026.
The military on the streets?
Yeah. I mean, National Guard, not the actual military, but there were lots of discussions.
We had Marines
about
in Los Angeles for a while.
Marines in Los Angeles. But again, these are the things that preoccupied them. And I'm like working on this book, and I'm like, this is everything they never wanted to see.
Wow. A lot of the conversations in the book kind of go back to understanding the intent of the framers, right? What did they mean when they said this?
Yeah.
How should we be thinking about that? Do we have to take into context they didn't understand the world that we live in now? How absolutist can we be about what we think they thought?
So there are 6 people on the court who think we should be very absolutist about it for guns. For other things, they're much more itinerant and selective about history and tradition. And I think
You've referred to it as drunk history.
on the podcast, not in the book.
Yes. Yes, to
The
be
book
clear.
is very decorous. It's intended for students. I think you have to call them out on that. I mean, if you're going to talk about originalism, I was down at Stanford Law School, and if you've ever taught at Berkeley, you go to Stanford and it's like country mouse come to the city, and you're just like, your head is turned. They have this wall of flat screen TVs, and it just like the TVs would flash inspirational messages. And then one TV said, "What is the greatest scam ever perpetrated by lawyers?" And I was like, well, I'm interested now. So I'm waiting for the screen to flash again.
Clickbait.
And then it just says originalism. And I'm like, oh my God, yes, that's right.
Wow.
That's totally it.
Like lawyer jokes on the walls.
It's a really good lawyer joke. Originalism, this idea that we have to interpret the Constitution the way the framers would have understood those provisions, I guess, right? I mean, I don't even think the framers thought that. I mean, they have a Ninth Amendment that says not everything in this document is exhaustive. This wasn't supposed to be exhaustive. There may be rights that we haven't contemplated that are implicit from other rights that we have to address and consider. And just because it's explicit here doesn't mean it's exhaustive. So, I mean, that by itself, the fact that they have this sort of basket amendment that's this isn't it, should tell us that they did not believe they had a monopoly on wisdom, that there were other things going on here. The whole Anglo-American system and legal tradition is one about analogy and reasoning by analogy. I mean, I don't think they would have looked at the Second Amendment and said, okay, did James Madison have an AR-15? Well,
Or
he had a
envision that
musket.
one could exist?
Yeah, right. He had a musket, so we can now allow people to have AR-15s. I don't think that's what they had in mind. And again, they're so selective about the history that they use. So in a recent case that was decided by the court in this term, Wolford versus Lopez, which was a challenge to a Hawaii law that prohibited gun owners from entering with their guns on private property unless they first secured the consent of the private property owner. The court struck down this Hawaii law as inconsistent with the Second Amendment. And I was like, this is really interesting, because if there's one thing the founding fathers really cared about, it was private property, right? Securing private property. So how is it that this law that gives priority to the wishes of a private property owner is eclipsed by the Second Amendment and the right to own guns? And Hawaii, in defending its law, pointed to anti-poaching laws that were in effect both in the Hawaiian Islands prior to statehood and in other places that said you couldn't carry a gun onto private property. And this court was like, but that was about hunting and poaching. It wasn't about gun ownership per se. So they narrow or expand the aperture depending on what they are doing. So then Hawaii's like, okay, that won't work for you. Here's another law. There's a law from 1865 in Louisiana that says that you cannot carry a gun onto private property. Seems like a good one. Like the Bruin, the test that the court has used since 2022 in Bruin versus NYSERPA is that you have to have a historical analog to show that the law in question to be upheld as consistent with the Second Amendment is within the history and tradition of the nation's regulation of firearms. So this would seem to do that. And this court said, we can't actually look at this law because it was a law passed in the throes of Reconstruction and part of the Black Codes, which were aimed at disarming the newly freed African Americans. This is the first time this court sees racism this term, right? A few days later, in the temporary protected status cases where they allow the administration to rescind TPS status for Haitian nationals and Syrian nationals, they don't think that the president's statements that Haitians eat dogs and cats and that Haitians are poisoning the blood of America or that Haiti is an S-hole country, that doesn't seem racist to them. But the Black Codes from 1865 and this law prohibiting the possession of a weapon on private property, that's racism, and we can't even consider it.
And none of this gerrymandering is racism.
Well, I mean, again, that's partisanship, right? So that also was just, again, a case that the court orchestrated and brought back. So this case, Louisiana versus Calais, which has effectively nullified Section 2 of the Voting Rights Act, which is literally the last shard of this historic civil rights statute that remained. This case was a challenge to Louisiana's districting maps. Louisiana, in the wake of the 2020 census, drew a new congressional map that only permitted a single district where African Americans were likely to elect the candidate of their choice, even though African Americans represent about a third of the electorate in Louisiana. So the map actually could have supported 2 minority opportunity districts. A 3-judge panel, which included Trump appointees, said that this was likely a racial gerrymander, and it ordered Louisiana to redraw the map. Louisiana redrew the map so that there were 2 minority opportunity districts. A group of non-African American voters sued the state, arguing that the new map, because it had been drawn to remedy the racial discrimination of the old map, was itself engaging in racial discrimination because it considered race. So considering race to remedy the racial discrimination is itself racial discrimination. This case was first argued in October term 2024. It was then supposed to be decided at the end of that term, so June of 2025. The court never issued a decision. They held it over for another round of oral arguments in October term 2025. And when they did that, they asked a new question that no litigant had asked for. No one was asking this question except the members of this court. And the question was whether the consideration of race as part of a remedy for a redistricting wrong, if under the 14th Amendment that was done, would it violate the 15th Amendment? So effectively,
They brought their own case.
yeah, they brought their own case, and the idea is, if you are thinking about racial discrimination as the 14th Amendment directs you to do, does that violate the 15th Amendment? So it's almost like, are the 14th and 15th Amendments in tension with each other? And the court ultimately says yes. It ratchets up the proof that would be required to establish a violation of Section 2. It insists that you have to show intentional discrimination, which no state is going to do. They're not going to be like, yes, I was trying to stick it to the Black people. Instead, they're going to say, I was trying to consolidate Republican advantage, or I was trying to ensure that the Republican incumbent stayed in power. When in fact, in many of these states, especially in the South, race and partisanship run together, which is to say that African Americans are Democrats in many of those states. So if you are districting to consolidate Republican advantage, you're doing it in a way that will necessarily disadvantage African American voters. African Americans are Democrats in many of those states. So if you are districting to consolidate Republican advantage, you're doing it in a way that will necessarily disadvantage African American voters.
Precedented?
Probably not. I'm sure if I thought about it, there are other times when the court has revisited questions or held over questions and, looked at them afresh. Even Louisiana versus Calais is very similar to a case that the court heard in 2023 called Allen versus Milligan, which was about Alabama drawing its maps in a way that limited the opportunities for minority voters. Alabama drew a single minority opportunity district when in fact the number of Black Alabamians would have supported 2 districts. The court in 2023 upheld a ruling of a lower 3-judge panel saying that the initial map that was drawn was likely an impermissible racial gerrymander. It's the same question that was raised in Louisiana versus Calais. Why the court felt it had to address the question again 2 years later is a question, a puzzle.
Yeah.
I speculate that in 2023, we are 10 years after the court striking down the preclearance regime of the Voting Rights Act in Shelby County versus Holder. So it's a bad anniversary, 10 years out. It's also the year after the court hobbles abortion rights in Dobbs, and they're already getting a lot of heat. So maybe they just, come back to this.
Go focus on something different?
Yeah.
There are 17 amendments after the Bill of Rights. They vary in significance, I guess you could say, to certain people. I grew up in the District of Columbia. Getting to vote is good. But the 13th, 14th, and 15th, the Reconstruction Amendments after the Civil War, it's not, but it's almost like a new constitution, right?
It is a new constitution.
Okay.
It is a new constitution. And again, this goes back to the point I was making about originalism. Originalism fetishizes the original Constitution in 1787. When they're talking about framers, they're talking about James Madison, and Gouverneur Morris, and George Washington. But the drafters of the Reconstruction Amendments, they're framers too, because that is a second founding. It is a separate and distinct constitutional moment where they are renegotiating the balance of power between the federal government and the states, and the federal government, the states, and the people. This is when they realize that the states, as much as the federal government, could be tyrannical, right? And they're trying to hedge against that. So it's a complete reworking of the balance of power, of what it means to be a citizen. It is the beginning of the seeds of a multiracial democracy. Originalism has a hard time with taking that seriously. I think maybe America has a hard time taking that seriously. We have just celebrated the 250th anniversary of the Declaration of Independence and the beginning of the American Revolution. We all know who the founding fathers are. Could we name the people who drafted the Reconstruction Amendments, which again restarts this country after a moment of profound rupture? Like, could anyone name who they are?
You would have had to just read that page in the book. I appreciate that you named the people who brought forth the amendments. None of them were names I recognized.
Bingham, Lyman Trumbull, Thaddeus Stevens,
Yeah.
Frederick Douglass. We're not taught those people in school. I wasn't. Maybe that's Florida. I don't know.
Partly, yeah.
Partly, possibly. I don't even know if I learned those names in college in a class about American history. We should
Right.
ask ourselves why that is. This is such a seminal moment in our history. Why aren't we teaching Reconstruction? Why aren't we teaching Redemption, which is when Reconstruction is literally abandoned 20 years after it begins?
Mm-hmm. And now, if you look at those 13th, 14th, 15th Amendments as a new body of the next chapter of the Constitution, how much of it is left?
Well, I think this court has done its level best to roll back the 14th Amendment, and certainly to hobble Congress and its authority to pass legislation in pursuit of the Reconstruction Amendment. So we've seen the court whittle down congressional power under Section 5 of the 14th Amendment, Section 2 of the 15th Amendment. That's huge because the Reconstruction framers thought that Congress would be in the driver's seat, would be the ones to enact the legislation that would make good on all of this. The Reconstruction Amendments, even from the start, were almost strangled in the cradle. I talk about this in the book. The Privileges or Immunities Clause of the 14th Amendment was really supposed to be the primary repository and source of individual rights. And the Supreme Court, in a series of cases, the civil rights cases, the slaughterhouse cases, effectively nullifies the Privileges or Immunities Clause. Then the Due Process Clause sort of steps in to become a source of rights, but it's imperfect. And I think it's one of the reasons why you've had so many conservatives rail against this concept of substantive due process. It really actually wasn't meant to work that way. It could, but the Privileges or Immunities Clause was really supposed to do the lion's share of this work. And there was very little litigation about the Equal Protection Clause until the 1950s. Oliver Wendell Holmes called the Equal Protection Clause like the last resort of bad lawyers. And so no one was thinking that was going to do anything either.
And now it seems to be all we're talking about, or one of the main things we're talking about.
Well, in large part because in the 1950s and 1960s, Congress, back in the driver's seat, starts using the powers that it was given. Not necessarily under Section 5 of the 14th Amendment. Some of this is done through the Commerce Clause, but Section 2 of the 15th Amendment is what animates the Voting Rights Act. Section 5 of the 14th Amendment helps animate the Voting Rights Act. They do a lot of work with Section 2 of the 13th Amendment. Like, this is where the civil rights movement gets the actual infrastructure to make good on the promise of a multiracial democracy. And it's those amendments that this court has really narrowed over the last 30 years.
It almost sounds like the system worked. The amendments get written and the Congress uses them to create
that was
laws.
the point. That's how it's supposed to work.
That's how it's supposed to work. You talked about this a little bit before, but a couple questions here about the relationship between Congress and the court. So the Congress could change the scope of what the court can rule on. The court, one justice seems to invite the Congress to do something specific. Is that relationship permanently broken? Is there a pathway to restoring it? Can we get back to a place, or should we get back to a place where the court interprets laws that Congress makes? Sorry if that sounds cynical.
Well, so it is supposed to be a kind of dialogical relationship, and we've seen it be a dialogical relationship in the past. So, Lilly Ledbetter versus Goodyear Tire results in a loss for Lilly Ledbetter. Ruth Bader Ginsburg writes a dissent that she reads from the bench that exhorts Congress to take steps to legislate to correct the injustice that the court feels it cannot correct sua sponte. And Congress takes it up. They passed the Lilly Ledbetter Fair Pay Act. So we've seen that before. With the Voting Rights Act, there's a decision from this court in Mobile versus Bolden in the 1980s, and Congress was like, nope, that's not what we meant about the Voting Rights Act. Like, we're going to say it again, louder for the folks in the back, and we're going to make very clear what we mean. So I think that's the way the relationship has worked in the past, could work in the future. I think one of the things that's alarming about this court is the way in which they insist that, there's Congress's lane, there's the court's lane, but sometimes the court does things that Congress is supposed to do, right? So in the TPS cases, for example, the temporary protected status statute requires the administration to engage in a consultative process with related agencies, usually the State Department, before rescinding temporary protected status. And while the executive's ultimate decision about whether to rescind or continue TPS is a non-reviewable decision by the court, it's not the case that the process of consultation and whether it occurred is non-reviewable. And that was sort of the argument that the plaintiffs in the TPS case had made. And indeed, there was New York Times reporting just before the decision was announced that suggested that Kristi Noem, the Secretary of Homeland Security, had not fully engaged in the consultative process. She had requested a review from the State Department, but hadn't waited until the review was returned before rescinding TPS. And so the court, in a decision authored by Justice Alito, determined that determination, as written in the statute, extended to the entire process. The determination, which is unreviewable by the court, is the whole process, not the specific decision.
Not the determination made at the end of the process.
Right, and so, which is maddening, because all of the time they are emphasizing, you have to look at what the text says. The text says what it means. Use the plain meaning of the text. I know what determination means. And it's not the whole process. It's this part of the process. And so it's those sorts of things. And, this is a court that says it stays in its lane, but I don't know that it always does.
A question here about the way justices get onto the court and the presidents who nominate them, and then the perhaps surprising deviation where justices over time don't vote the way you think the president who nominated them would expect. Is that notable, surprising, routine?
So Andrew Martin, who's now the president of Washington University, and Kevin Quinn, who used to be my colleague at Berkeley and is now at the University of Michigan, maybe actually he might be at the Washington University at this point, they had these Martin Quinn scores where they basically rated and evaluated the ideological drift of justices over time. And it actually wasn't specific to any particular ideological stripe, like who nominated you. all of the justices kind of moved to the left over time. So it was really just like a consistent drift leftward. And, they argue that like maybe as you are on the court for a long period of time, you just become inured to certain practicalities, to partisan politics, and you kind of just shift. I'm not quite sure if that's a persuasive account of why that happens, but empirically it seems like that is what happens. The most famous example of this, I think, is Harry Blackmun, who was nominated by Republican President Richard Nixon and ultimately wrote Roe versus Wade. I don't know if that's necessarily an example of ideological drift, though, because in 1973, many Republicans were in favor of abortion rights. So what Blackmun was doing in Roe was not especially radical, and Roe is not an especially radical opinion. John Paul Stevens is another example. He too was nominated by a Republican. By the end of his career on the court, he was very much a lion of the left. But there was a long tail to this, and he was on the court for a very long time. So he wasn't like immediately got on the court and became a Berkeley hippie.
Who didn't wear blazers.
Right.
Fascinating question here. Many democracies have revised their constitutions more often and more aggressively.
Yeah.
Should we? Is there a space for a broader range of amendments or a constitutional, sort of a fresh constitutional convention?
So I think part of our problem is that it's really hard to amend the Constitution. Article 5, which lays out the provisions for amending the Constitution, makes it pretty hard, and that was by design.
Right?
Yeah, by design. I think they felt that if you were going to go to the trouble of writing all of this down, you wanted to make sure that these weren't itinerant commitments that could be changed on a whim. And if you think about certain moments in time, you can understand where they were coming from. So imagine post 9/11 in this, furor over safety and, concern about the homeland. There might have been many among us who are willing to give up certain civil liberties in the name of public safety.
We did to some extent.
Not all of them. We could have gone even further, but the First Amendment was a hedge. Other amendments were a hedge on that. So maybe that's a good thing, right? I think what the founders did not anticipate is the impact of political parties, polarization, gerrymandering on the process. You have to go through state legislatures. There are two processes. There's the process by which an amendment originates in Congress, and then it passes by a supermajority in both houses, and then goes to the state legislatures where you have to have 38 states in order to be ratified. That's a lot harder now because of gerrymandering, both at the level of Congress and at the level of the state legislatures. There's an alternative method, it has never been used, whereby an amendment originates in a state constitutional convention. It's never been used. There's incredible appetite to use it among red states right now. So they're basically counting how many red states and red state legislatures there are where they control the legislature. And if they get to the point where they're in striking distance of a supermajority, I think they will call for a state level constitutional convention. And who knows what they'll do? It might not just be a new amendment or a few amendments, it might be a whole new constitution.
Wow. Speaking of those kind of changes, the Electoral College, somewhat anachronistic thing in the Constitution. I say related because this idea of a national compact where a number of states are getting together trying to change it, and if they get enough states, they'll be able to change it, right?
Yeah.
Is that the same approach? Is that even? It seems awfully close. It seems like you're amending the Constitution without amending the Constitution, right?
Right. So Jesse Wegman's book on the Electoral College, I think is great for this, and it has a really wonderful explanation of the national popular vote movement and this compact for the states to sign on that, they're just, rather than doing the Electoral College, they'll just do the national popular vote and devote their electors the way the country votes. Obviously, this would effectively do what abolishing the Electoral College would do through an amendment. It just doesn't require an amendment.
we've come so close to electoral college reform through the amendment process. So, Birch Bayh, who is a senator from Indiana who was the chairman of the Senate Subcommittee on Constitutional Amendments for many, many years, shepherded most of the amendments, basically 23 through 26 to completion. And he came very, very close with the the amendment that would have abolished the Electoral College. Didn't quite make it. There's a story there, I think, about Birch Bayh and his faith in the amendment process as a means of constitutional change. Also, a story, I think, about the events that precipitate the impulse toward amendment. So, the 25th Amendment, which specifies all of the procedures for addressing presidential incapacity, is born of, some of the gaps and vagaries in Article 2, but it is precipitated by the Kennedy assassination and this realization that what if John F. Kennedy had not died immediately in Dallas? What if he had held on, as, for example, James Garfield did for many, many months before ultimately succumbing? Is Lyndon Johnson an acting president? If so, for how long? Is he the president? What happens? And Article 2 doesn't really explain that. Again, the framers aren't perfect. The document's not perfect. There are so many moments in our history that give rise to these realizations that, wait a minute, we could do this better. We probably need to pin this down a little more. And I wonder if the moment we are in right now, irrespective of the challenges of amendment, if this moment will provide the urgency to maybe look forward to maybe closing up some of these loopholes.
Every time there's an election where the popular vote is out of sync with the Electoral College, you hear this conversation.
Yeah.
The popular vote compact still requires the state legislatures to actually do what they promised they would do every time you have an election, right? Which is the argument for having an amendment.
But this is also the problem, though, of state legislatures that maybe aren't high-minded, and that's a real worry.
Back to your native state of Florida.
Native is such a strong word.
Sorry. Yes, good point. Good point. You mentioned things like identifying the people who brought forth these amendments, the lesser-known things in sort of the history of the Constitution. Did your thinking change at all about the Constitution as you forced yourself to really read it word for word and write this book and create the context? Did you learn new things? Did you?
Yeah. So, one, I remember doing Article 1, and Sam can attest to this. Wow, this is a slog. This is really long. They covered a lot of things here.
Yeah.
Postal roads, all kinds of things. I think when you read through it, you begin to understand what their anxieties are. I mean, Article 1 is long, it is lengthy, it is enumerating all of the powers that Congress had because they were so worried about Parliament. They didn't want a federal legislature that would be like Parliament. And so, when I say this is a trauma-informed document, I really do mean it. It's like if you have gone through a traumatic experience and you go to a therapist and the therapist tells you to journal through it. That's what they're doing.
That's what they did.
That's what they're doing. Genuinely. I mean, you see, there's so many places in the Constitution where they're talking about this standing army and their anxieties about the standing army. It's all over Article 1. It's in Article 2. It's in Article 4. I mean, it's there's all sorts of stuff.
They had redcoats outside their doors, right?
You also, the other thing that I think is, this wasn't so surprising to me because I'd read the Constitution before, but slavery is all over the Constitution, but is never explicitly named. It's everywhere in the original Constitution, and you begin to understand once you're looking for it, the sort of hidden clues. Anytime they mention the year 1808, that's about slavery. Because they had this idea that the South just needed 20 years to wean itself off of slavery. So in 1808, that was when Congress would be authorized to pass a law to end the transatlantic slave trade. They could not do it before that. And that's actually in Article 1. Congress cannot pass a law limiting the transatlantic slave trade until 1808. And 1808 comes, Thomas Jefferson himself, a notorious slave owner, signs the law into being. And the South says, bet, we're not ending slavery. We're just going to shift to a self-reproducing slave population. So
they're trying to sort of come at these compromises that will end what they understand is a divisive question that may well end the whole experiment because it's just so fraught. I think they understood that from the start. But if you go through the original Constitution, it is in Article 1, the compromises, the 3/5 clause, the compromises over the size of the House of Representatives. It's in Article 4, the requirement to render personal property back to the state where it came from. Like, they're not talking about furniture. Like, they're talking about people.
Yeah.
And these compromises, accommodations of slavery are literally all over the document, which is what makes the Reconstruction Amendment so profound. I mean, it's basically, we're going to start all over. We're wiping this clean.
And we're going to use the word this time.
Yeah.
Yeah. What you mentioned being the child of people who weren't lawyers. How did you end up in the law? What drew you to the law and to teaching it specifically? Not that we all don't need to learn. I get that part.
Yeah, so I went to public school in Florida, and in the 5th grade, we were given an assignment where we had to look up our birthdays and find something significant that happened on our birthdays. Wow. And this was before Google. I mean, this was like before the internet. So
you
it
had
was
to actually
actually
look
a
it up.
hard assignment. It was a really hard assignment. And I was born on August 30th, and I was like searching. I had to get a reference librarian at my local library to help me. And finally, we came up with Thurgood Marshall was appointed to the Supreme Court on August 30th.
Wow.
And I was like, well, who's this guy? And so I started reading about Thurgood Marshall, and I was like, what is the Supreme Court? I'd never heard of it. I mean, we hadn't yet gotten to civics in my elementary school class. That came in 6th grade. This was a 5th grade assignment. I crushed it when we finally did get it.
I bet you did.
I really did.
I bet you did.
But that was sort of the beginning. And I was like, wow, this, when you read about Thurgood Marshall, not even his career on the court, it's really his career before the court that is so impressive. Like,
Yes.
this man completely changed the law. And
The country.
And when you're growing up in Florida in 1985, I think you realize segregation is literally in the rearview mirror. Like, it really is. Your friends' parents grew up in segregated schools.
right.
And, when I was in school in Florida, they still, at the beginning of every school year, took a role where not only were you asked to identify yourself as present and with your name, you were asked to identify your race because we were still under a consent decree for integration.
That explains how you got here. It's fascinating. I can't wait to see your daughter's first case before the Supreme Court.
She wants to be a chemist.
Okay. Didn't see that coming.
Me neither.
Melissa Murray, thank you. The book is The U.S. Constitution, a comprehensive and annotated guide for the modern reader. It is outside the doors here as you leave. I'd love to have you pick up a copy here or at your local bookstore. You can get more information about the Commonwealth Club World Affairs membership and programs at commonwealthclub.org. And thank you for the conversation.
Thanks
Appreciate
so
you being
much.
here.
Thank you.
Thank you.